Please hear the case.
Good morning. This is case number ICTY 0367 PT, the prosecutor versus Vojislav Seselj.
Thank you. And the appearances, please, for the prosecution.
Good morning, Your Honor. For the prosecution, Carla del Ponte, then Saxon trial attorney, Kimberly Flaming, case manager. Thank you.
Thank you. And
microphone, please, for the accused. On behalf of the accused in person, Your Honor.
Thank you very much. Under Rule 62, I have to satisfy myself that you are aware that you have the right to counsel. We are aware that you have sent a letter of about 100 pages in handwriting. Unfortunately, it was not possible to translate it until now, therefore we can't take it today into consideration. But is it still your perspective that you want to defend yourself?
Yes, and nothing will change in this respect until the end of the trial.
We will see. We are still seized with the motion by the Office of the Prosecutor requesting the assignment of defense counsel, but as mentioned beforehand, we can't decide before we have heard what your remarks on this issue are. Then, following Rule 62, Roman 2, I have to satisfy myself that you have the indictment in a language you understand, and may I ask, are there any problems related to this? During the last appearance, you indicated there would be some problems. But let me tell you this, based on your intervention, I got into some details of this, as you called it, problem. First of all human rights issues have the same language and telling us that it's a fundamental right of an accused to be informed promptly and in detail in a language which he understands. This is Article 14, 3a of the International Covenant on Civil and Political Rights of December 16, 1966. So does the Human Rights Convention for the Protection of Human Rights and Fundamental Freedoms of November 4, 1950, in Article 6, 3a, where it reads that the accused has to be informed promptly in the language which he understands. From this it follows that in our statute it reads in Article 21, Arabic 4a, that the accused has to be promptly informed and in detail in a language which he understands. You made some objections to the use of some words. For example, the word obshi opposed to obshti, the word tochka opposed to tachka, and others. I went into some details, and in my conclusion, there's not the slightest doubt that this is the language you understand. We have the common roots in the Herzegovinian Serbo-Croatian language, and what we are discussing here are not dialects, not even dialects. These are variants of one and the same language. And the basic document, I'm convinced that it's not only in a language you understand, but also the language you are using. Because whenever those words mentioned by you, for example, the word for defense, which would be in the Croatian variant obrana, and in the Serb version odbrana, you can read the Serbian version in the indictment. Therefore, I have to ask you, are there any other objections to my understanding that you have the indictment as such before you in a language you understand?
This is correct, Your Honor. I have received the indictment in the Serbian language. However, it was not read out in its entirety in the Serbian language. There were many expressions I do not understand. Like you, in the meantime, I consulted some linguistic experts about some words which I absolutely do not understand. These experts explained to me that the noun točka could be the feminine variant of the word točak. And as for the word hotimično, and I still insist I do not understand it, they explain that there is an Albanian tribe called Hoti, and mično would be derived from micatisa, which means to move, so it would mean Hoti moving, or someone moving in the way the Hoti move. These are big problems, and I insist that you find an interpreter who can speak the Serbian language well. I cannot speculate. The word hotimično is an artificial word, and it sounds in Serbian just as Cockney might sound in London in relation to standard English. It is my right to have the interpreter interpret to me in the Serbian standard language and not to use some sort of jargon or an artificial language, a language used in Zagreb and elsewhere. I have received the indictment in the Serbian language, and I can plead today to all counts of the indictment, but there is another very important problem. Let me remind you that Article 20 of the Statute, under 3, says the trial chamber shall read the indictment, shall convince itself that the rights of the accused are respected, and shall ask the accused to plead. Your Honor, with all due respect, because I see that you are acting properly, I do not see the chamber here. It says in Rule 62, the accused shall without delay be brought before the trial chamber or a permanent judge thereof without delay, and shall be formally charged. The trial chamber or the judge shall to read or have the indictment read out to the accused in a language the accused speaks and understands, and satisfy itself, himself or herself, that the accused understands the indictment. However, if the rules of procedure and evidence are not in accordance with the statute, it is the statute that has precedence, because the statute was brought by those who founded the tribunal, while the rules of procedure and evidence were brought by the tribunal itself. This may seem to be a formal issue to you, but I feel that it is essential. I feel that the entire chamber should be present when I am pleading, because I feel that this is a very very important part of the trial, maybe the most important. I wish to look all the members of the trial chamber in the eye. I want them all to see what my bearing is and whether I'm convincing or not when I plead not guilty. And also it says here that it is the trial chamber that should read out the indictment and not just any clerk of the court. Therefore, I demand that the indictment be read out again, that it be read out by the trial chamber. You don't all have to read it, or you don't have to read all of it yourself. The judges might take turns reading it. And I feel that all the provisions of the statute first and the rules of procedure and evidence secondly should be respected. If there is any conflict between the statute and the rules, it is the statute that should be strictly respected.
Dr. Šešelj, I appreciate that you admit that you have the indictment before you in a language you understand. As regards the rules of procedure and evidence, there is a huge discussion given to the judges implementing the statute, and under the statute it clearly reads that a pretrial judge has to do this initial appearance, and you have followed the decisions from the President assigning the case to the trial chamber and then assigning the case to me. So there is no procedural problem. I'm here sitting as a representative of Trial Chamber 2, and then we may proceed immediately under Rule 62. You are informed, and I have satisfied myself that you have the indictment in the language you understand. So therefore may I ask Madame Registrar to read from the indictment count by count the charges.
Count 1. Persecutions on political, racial or religious grounds, a crime against humanity, punishable under Articles 5H and 7.1 of the Statute of the Tribunal.
Thank you. May I hear your plea?
Not guilty. Not guilty.
Please, number 2.
Count 2. Extermination, a crime against humanity, punishable under Articles 5B and 7.1 of the Statute of the Tribunal.
Not guilty.
Count 3. Murder, a crime against humanity, punishable under Articles 5A and 7.1 of the Statute of the Tribunal.
Not guilty.
Count 4. Murder, a violation of the laws or customs of war, as recognized by Common Article 3.1a of the Geneva Conventions of 1949, punishable under Articles 3 and 7.1 of the Statute of the Tribunal.
Not guilty.
Count 5. Imprisonment, a crime against humanity, punishable under Articles 5e and 7.1 of the Statute of the Tribunal.
Not guilty.
Count 6. Torture, a crime against humanity, punishable under Articles 5f and 7.1 of the Statute of the Tribunal.
Never in my life have I ever tortured anyone, and I am not guilty.
Count 7. Inhuman acts, a crime against humanity, punishable under Articles 5I and 7.1 of the Statute of the Tribunal.
Not guilty.
Count 8. Torture, a violation of the laws or customs of war, as recognized by Common Article 3.1a of the Geneva Conventions of 1949, punishable under Articles 3 and 7.1 of the Statute of the Tribunal.
Not guilty.
Count 9. Cruel treatment, a violation of the laws or customs of war, as recognized by Common Article 3.1a of the Geneva Conventions of 1949, punishable under Articles 3 and 7.1 of the Statute of the Tribunal.
Not guilty.
Count 10. Deportation, a crime against humanity, punishable under Articles 5d and 7.1 of the Statute of the Tribunal.
Nisam kriv.
Not guilty.
Count 11. Inhuman acts, forcible transfers, a crime against humanity, punishable under Articles 5I and 7.1 of the Statute of the Tribunal.
Nisam kriv.
Not guilty.
Count 12. Wanton destruction of villages or devastation not justified by military necessity, a violation of the laws or customs of war, punishable under Articles 3b and 7.1 of the Statute of the Tribunal.
Nisam.
Not guilty.
Count 13. Destruction or willful damage done to institutions dedicated to religion or education, a violation of the laws or customs of war, punishable under Articles 3d and 7.1 of the Statute of the Tribunal.
Opet mislim.
Again, you are mentioning these Albanian Hoti, the Albanian tribe of Hoti, but I'm not guilty.
Count 14. Plunder of public or private property, a violation of the laws or customs of war, punishable under Articles 3e and 7.1 of the Statute of the Tribunal.
Nisam kriv.
Not guilty.
Thank you.
Gospodine sudio,
Your Honor, with your leave.
Moment, please. Madam Registrar, we can conclude that the accused has pleaded not guilty to all the counts of the indictment we have before us. This concludes the first part, the further appearance, and let's turn now to the status conference in order to discuss the remaining administrative issues. May I
ako dozvolite, ja imam tu.
With your leave, Your Honor, I have something to say about the first part.
This is already finished. Let's go to the second part, and there will be time for you to address these issues during the status conference. May I first ask the prosecution, what about the actual disclosure?
Yes, Your Honor. Our disclosure to the accused of the supporting material is completed on Friday under Rule 66AI. So we have no further, at the moment we have no further document to disclose to the accused.
Yeah. The second point would be we are still seized with the motion of the prosecution requesting the assignment of defense counsel to the accused. We can't deal with this issue today because we don't yet, as mentioned beforehand, don't yet have the translation into English. From this we have two problems. The first problem is that Dr. Šešelj, unfortunately, in part, your handwritten 100-page document is not legible. I'm convinced that the translation unit will do the very best in order to find out and to translate that what is possible. But maybe we have to come back to you and to ask you the one or other question. May I ask you, there are two possibilities. We can provide you with a laptop or with a typewriter. What would you prefer?
Ja ne bih.
I would like neither a laptop nor a typewriter because I am afraid of receiving an electric shock. But I will kindly assist your translators if they have any problems in translation. If I can sacrifice my fingers and deform them in writing 100 pages in response to the prosecution's motion, I think that the court must ensure translators who will translate this into the official language of the tribunal. because I'm in a far worse situation than the prosecution is as regards the writing of submissions and various documents. I have far less personnel at my disposal than the prosecutor has.
Do I understand from this that you are requesting legal aid?
Zašto pravnu pomoć?
Why legal aid? I have never met a better lawyer than I am in my whole life. I don't need legal aid. But typist, yes, I could use that.
We have to decide on this. You have the offer to make use of a laptop. You have the offer to make use of a typewriter. And especially making use of a laptop will facilitate your defense because numerous documents are best accessible by a laptop because you can find some documents on CD-ROM and in an easy way to find. But let me first, I'm afraid you didn't get this document beforehand. I have to tell you that there is a guideline, a direction on the length of briefs and motion, and therefore, for example, your response to the prosecutor's motion on assignment of counsel should not have been more than 10 pages or 3,000 words. These are rules. They were
What are these rules, Your Honor?
I ask the usher to give one copy of this document in the Serbian language to the accused.
This is the first time I'm seeing this document. This was certainly not among the documents I received. But all my previous submissions, and there have been 5, were half a page long. And the translators were very successful in their translation. I assured myself of that. However, my preliminary motions as to the indictment in relation to jurisdiction and formal defects will also be over 100 pages long. I have already started writing this. This cannot fit onto 10 pages. In view of the seriousness of the indictment, I may have to write over 100 pages. As you can see, I'm taking this job very seriously. I don't need any lawyer to hinder me in this. As far as I know, until the beginning of the trial, I only have to submit my preliminary motions. Unless the prosecution continues to bombard me with these kinds of illegal requests, because the prosecution is abusing its rights, submitting motions which it knows in advance cannot be approved. No one in the world can deny me the right to defend myself. No one can impose defense counsel on me, as you call them. So please tell the prosecution to submit only serious motions so that we will not waste time on motions like this one, which they know in advance are unacceptable.
The chamber in its entirety will decide on the motion filed by the prosecution, and a comparative approach shows in fact that there might be some merits in this request, but as mentioned, this is not the day to decide on this.